Hello, everybody. Good afternoon, ladies and gentlemen, and colleagues from around the world. My name is George Walden, and I'm your host today. And we are fortunate today to be speaking with and interviewing a colleague from Meissner-Bolte. I would like to introduce you to a wonderful person, as well as a very successful patent lawyer from the firm Meissner-Bolte. His name is Tilman Pfrang, and he specializes in all matters of intellectual property law, in particular patent, utility models, trademark, design, and license law. Ladies and gentlemen, without further ado, please welcome Mr. Tilman Pfrang. Thank you for joining us here on the UPC Front-Loaded podcast today. Tilman.
Hi, George. Thank you that I can be here.
Yeah, again, I'm glad to have you here. Glad to have you here. I'm looking forward to this because, as you know, our topic today is the UPC Front-Loaded podcast. And I actually did some research and I went to the dictionary to see what it means, front load, to front load anything. So it's to put or have more payments, charges, activities, etc., close to the beginning of a period. The training program is front loaded so that you begin to acquire knowledge and skills right at the start. So just so our listeners can have a small view of what we may be talking about today. So my question, so Tilman, the episode title for today revolves around the theme, the UPC front-loaded, with an eye on the front-loaded nature of the Unified Patent Court UPC proceedings. And I have 12 questions, or a few questions, if you can answer any of them, that I hope that you can give us some further insight on. And the questions that I will be asking you are designed to cover the basic concept, the ramifications, and the detailed aspects of the front-loading in the UPC proceedings. So Tilman, with all of this big ta-da, are you ready to enlighten us with some questions and some answers that we might have?
Yeah, sure. I'm ready.
Okay, let me start off with this, okay? The questions that can help set the stage for the listeners who might not be familiar with the term, but what does front-loaded mean in the context of UPC proceedings? That's the question.
That's, of course, the basic question. Yeah, George, I mean, more or less, I would say you got it. I mean, probably you will remember school.
Yeah, a little bit of it.
A little bit of it. Same as me. You might remember that there was a summer break, a longer summer break, and then the long school year. What front-loaded would mean in that scenario would mean that during summer break, you would prepare all the school year with all gathering of books and research and gathering information, so that at the first day of your school year, you'll be ready for doing everything, every examination or whatsoever.
Wow. Okay.
Would mean also that maybe there's a final exam at the end of the school year where everyone else would maybe prepare their exam. You would be ready.
Yeah.
And this is exactly what the UPC is requiring from us.
Okay.
So what it actually refers to presenting all the major legal and factual arguments. So the facts, evidence, and so on at the very beginning of the process. You must be ready even before you start the proceedings, even before you start your school year.
Wow. And that sounds like a lot to have to deal with. So then that brings me to the second question, which is the rationale behind the structure. Why is the UPC structured to have a front-loaded approach? And how does this differ from traditional patent litigation systems like the EPO or, for instance, like the US litigation?
This approach, the UPC's front-loaded approach, is actually designed to streamline more or less the resolution of your patent disputes.
Okay.
By requiring that substantial parts of legal and factual arguments, again, are presented early in the process. If you compare that with the EPO or the US, let's start with the EPO.
Okay.
There is a lot of similarity. So similarity to the EPO proceedings, there significant amount of information, facts, evidence, claim amendments, or even arguments need to be presented up front.
Okay.
So at the beginning of the opposition phase, either if you're on the opponent side with your opposition submission, opposition letter, or if you're on the defendant side with your response to the opposition. So I would say both systems, the UPC system and the EPO system, aim to clarify major issues early, potentially leading to quicker resolutions. In contrast, as far as I understand it, I'm not a US lawyer, I have to admit, but in contrast, the US patent litigation seems to involve a more extended discovery phase after, or very much after, the initial pleadings.
Okay.
So this additional phase would allow them in the US
Mhm.
to disclose or uncover additional facts and refine arguments time by time, which then can lead to a longer period before reaching the actual trial.
Okay.
So maybe I can add that while this provides, of course, flexibility. I mean, you can adapt your case, you can amend your case very easily. So it's a very flexible approach. However, on the other hand, probably it leads to more complexities and difficulties, so more time.
Okay.
So I would say, I mean, in the US, maybe they are looking even more for finding the actual truth.
Okay.
Whereas there's more pragmatism at the EPO or UPC.
Okay, gotcha. Okay. That's interesting. So then that brings me to the next question. So a walkthrough of the UPC process with the emphasis on front-loaded stages to provide a little bit of clarity. Can you explain the key stages of a UPC proceeding and where the front-loading primarily plays a role?
Yeah, that's a good question. In UPC proceedings in general, we have three main stages: the written proceedings, the interim procedure, and the oral hearing at the end.
Okay.
However, the absolutely dominant role is the written proceeding, so the first stage.
Okay.
And again, here the front-loading nature, I would call it, is extremely important in that this is the most decisive stage and the beginning of the written stage, actually. So the lawsuit itself, the statement of claim, or the defense to the lawsuit. There actually, whatever is not in this submission, you cannot be certain that you can even use it in the later.
Oh, that's okay.
So more or less, the written proceedings is extremely decisive. The interim procedure, not so much. I mean, we have now had some cases. I would say it's a rather short, not very time-consuming, more managerial period. And the oral hearing is usually 1 day at the end. So if you compare that with all the hours and days and weeks you prepare or you need for the written proceedings, it's also not that relevant in comparison.
Wow. Okay. I would have thought that was a different aspect, but that's about as clear as you can get it. What advantages can listeners understand or purpose or efficiency of the system? What are the benefits of having a front-loaded system in patent litigation?
Yeah. Again, a good question. I would say that the benefits include kind of a greater predictability in the outcome. I mean, again, if the rule is that you have to present everything at the beginning, then it's at least more clear how it goes when compared with a situation where, well, let's say 10% is defined at the beginning. So I would say, a higher predictability in the outcome. Also, the system probably allows both parties to understand the strengths and weaknesses of their case very early.
Right.
So this could, again, lead to an earlier settlement or something like that.
Okay, yeah. Okay. Have you had many experiences in that situation like that? I mean, where it's gone to your benefit just outside of the box? I mean...
Yeah, actually, yes. Not so much. I mean, we didn't have so many cases at the UPC so far, but we did a lot of German. We didn't do a lot of German patent litigation, of course.
Right.
And yes, I can confirm that also from a practical perspective, that settlements are, likely at the very beginning, not so much at the later stage, which again shows that, the information is present at the beginning. And therefore settlement is at least possible.
Yeah, that's okay, definitely. This is that's interesting. This will offer a balanced view addressing potential complications of criticism. So my next question goes with, are there any challenges or drawbacks associated with front-loaded nature of the UPC?
Yeah, well, the big challenge is, of course, the preparation of the case. I mean, again, consider you are at school or actually in a summer break and you need to prepare for the whole school year. This is challenging. So you need a lot of resources, a larger team. Everything must be ready, must be at hand, and must be prepared. this is a huge challenge that we are facing, obviously.
Right.
A drawback, you mentioned a drawback. Yeah, well, this is again what I said maybe before. A drawback is that at a certain stage of the proceedings, I have to say it like that, the actual truth
Yeah.
is no longer relevant.
Wow.
Because if the court says, well, this fact may be true or not, will not be considered. Then they account for, of course, that the case will be decided on only a part of the truth. It may sound extreme, and then of course there is certain discretion for the courts in dealing with this issue, but in the end, it's unlike in the US, as I understand it, where they really have this discovery procedure where every detail, every fact is to be shown.
Okay.
That maybe the one or other fact speaking for your case is not even considered.
Wow. That's interesting. All right. Well then getting back to that, then a focus on practical implications for the involved parties will make discussion relevant or wider to an audience. So the question leading up to that is, how does front loading affect the preparation process for both the plaintiffs and the defendants in a patent case?
It means you actually need to make your first move with your, again, homework, sorry for that, homework fully done. You need your facts straight, your documents aligned, and your arguments must be actually sharp from the very beginning. There is not much opportunity to resharpen them.
So you're saying preparation is key?
Key.
Yeah, I can imagine. Okay. So the real or hypothetical case studies can make the concept more tangible. So in this case, could you give me examples of how front loading can influence the outcome of the patent disputes?
Yeah, well, I can think of an example, to be honest. Let's assume, I mean, always in our patent world, what's the decisive issue? It's novelty and inventive step, something like that.
Okay.
When it comes to inventive step, we very often present our prior art documents, and then we present our arguments that, for example, document D1 and D2 in combination render obvious the subject matter of the invention, so that it's not inventive. Let's assume in that case we presented these documents D1, D2. We presented also document D3. Okay. So you would say we did our homework, preparing our case. All facts are at stage. Then still we may face problems. One problem, for example, might be the following. Let's assume in our statement of claim for revocation action, we said, well, document D1 is novelty destroying, and documents D2 and D3 rendering obvious the subject matter of claim 1. Then later on, we are basically using the same facts, but in a different way. We now say, well, document D1 in combination with document D3 is rendering obvious the subject matter of the claim. Okay. And then it may well be that if we do that at a later stage, the court will say, well, yeah, these facts are from the beginning in the proceedings, but this is a new line of argumentation. You never said D1 plus D3 is rendering obvious the subject matter of the claim, so that we simply don't allow it. We don't even look in depth into it.
Wow. So that goes with your thing that you have to be prepared. It's all about preparation because you don't know what you'll be able to use or not.
Yes, and you must be, maybe I can add that at this case, you must more or less foresee all these possible developments in the case also. I mean, you must try at least to foresee that maybe it could be relevant for your case, that you also present an additional argumentation, in our case, combination of D1 and D3. Because you may use it later. So this is one of the difficulties,
Okay, well, that's pretty interesting. I didn't think about that. Okay. Advice on strategies that will be valuable for professionals listening to the podcast that you can give them, Zamaishville. For example, what strategies should legal teams adopt to effectively manage the demands of a front-loaded process?
Yeah, I would say that first of all, you need a proper legal team size-wise. Okay. I mean, this is again the issue of resources. You do not have much time in many situations. You cannot wait forever to file your statement of claim, but you must file it in a proper way. This is the difficulty. Therefore, it must be a larger team. Maybe 3 people is maybe enough in some situations. 4 or 5 probably would be better, or even more depending on the case.
Okay.
And then really the legal team must perform a thorough initial case assessment, leverage everything what they can for the case, collect evidence, and so on. And of course, as a little bit as always, but here specifically, an efficient, effective communication with the client to gather all that relevant information is,
I guess
in
it's
my
very
opinion, key.
important. Yeah. Wow. And just a quick question to that with your team. How do you go about choosing the best team for you when you're in a case and you need to find people that you know from your team? I mean, is there a confidence that you have in your team, or do you know exactly what you need before going into the case, or the preparation of who you want to work with, or it's just one of those interesting things because your team is obviously going to help you prepare.
Yes, this is an interesting good question. I mean, in the end, because we are usually talking about or always talking about technology if it comes to the UPC, I would always recommend that you establish your team based on the technology. It does not make a lot of sense to have a pharmaceutical expert for an engineering case or something like that.
It's not okay. Not a dentist for a heart procedure. I see. Okay.
Yeah, so different to maybe football or so, or soccer as you call it.
Yeah.
You usually will have tailored teams.
Okay.
So this is the one thing on the technical side, that you really have your technical experts for the technical field. At Meister Bolte, we are happy that for every technical field we have a lot of experts, so we are very flexible in that regard.
Right.
Also, maybe it's not that decisive, but could be relevant also for the legal questions, that you have maybe the one or the other lawyer who is extremely experienced in inspection proceedings or something like that. What you need in that case, then this person should be in our team. And again, in Meister Bolte, we believe that we have for every common proceedings or specific possible specifics of the case, our legal experts too. So I would recommend that you should be flexible. You should know the people, of course, you're working with, but you should be flexible and establish a tailored team.
Good to know. So discussing time and financial implications highlights the practical impacts of the system. So in what ways does the front-loaded approach impact the overall duration and the cost of patent litigation in the UPC?
I think by addressing these major issues early, or you are forced to address them early, this approach can significantly shorten the duration of proceedings and potentially also reduce the costs related to any potentially prolonged litigation. Because again, if you compare it a little bit to the US, where you have this huge discovery proceedings, we don't have that. So this is, in the end, it's also saving time. With a drawback, we have talked about this, but I think, in a rather, let's say, cost-efficient way, you get a good result if you are playing according to the rules of the UPC, of course.
Okay. I think that's probably a lot different from the US, but anyways, okay. Connecting the UPC's approach to broader themes like innovation can widen the podcast's appeal. So how does the front-loading approach of the UPC benefit innovation and technology development across member states?
I would say, this quicker resolution we have talked about more or less encourages the business and innovators to invest with higher confidence in new technologies and innovations. Also, you can maybe say it a little bit like that. I mean, if you clear the runway quickly, because you can settle the patent dispute very early, then you have space for new ideas to take off more or less, right?
Right.
So this is the idea behind it.
Okay. And I know you're busy, but I have one more question for you, so bear with me, but I think it's important. So this concluding can engage listeners in thinking about the future developments of UPC practices. Looking forward, do you anticipate any changes or reforms to the front-loading aspects of UPC proceedings?
Well, I would have at least a wish list, I would say.
So what would the wish list consist of?
My wish list would at least comprise that my impression is for the moment that some orders we have seen are really tough in that, well, your line of argumentation XYZ was submitted very late. We will not even more or less listen to it. This is,
Wow.
for me, it's a bit too extreme. What we know from the EPO is that always, at least at the first instance, there must be a kind of a prima facie examination. So you
Okay.
present a new fact or a new argument or new evidence, and then they at least prima facie consider whether or not there might be something behind that. If yes, they dig really into the specifics. If not, they say, well, we do not admit it because it's late filed, because we don't see prima facie that's relevant. I would like to see a little bit more at the UPC, because I think this is a very balanced intermediate approach, a little bit even between the US and at least some cases. I mean, it's very few number of cases, we must not forget, at the UPC, where I've seen a rather extreme approach that not even such prima facie considerations played a role. So that would be my, the major point of my wish list, that they may find a more balanced approach here, maybe somewhere in the direction to the EPO approach, which I find very reasonable. Yeah.
Do you feel that there is a chance that would happen, or is this a dream, or is something that you think in the next 2 years or 5 years or 10 years?
It's absolutely possible. I think we will receive a lot of guidance from the Court of Appeal in the coming years. And I think it's absolutely possible that my wish comes true. Yeah.
No, fantastic then. Well, with that, I know you're a busy man, and I just want to say, wow, I really enjoyed our conversation today with you, Tilman, on our podcast theme, the UPC Front Loaded. And if you would like to view the podcast or any other of our previous podcasts, be sure to check out our YouTube and website at www.meissnerbolte.com. Tilman, we really enjoyed having you as a guest, and we look forward to you and your colleagues coming back on our show to discuss different topics in the area of patent law. I think, I had a really interesting time finding out all these things, and I did some research, but listening to you, I think I feel much better about where we're going. So thank you very much for coming on.
Thanks a lot, George. It was really fun. Thank you.
My name is George Walden. On behalf of Meissner Bolte, Tilman Pfrang, and myself, we would like to say thank you for listening. And if you have any questions or topics you would like us to talk about, feel free to contact us. Until next time.